Hi everybody, this is Robert Miller from expertlawfirm.com, and I want to talk to you in this video about a particularly serious crime in the state of California, and that's being charged with Health and Safety Code 11351, or possession with intent to sell narcotics or legal drugs. As you can tell by the description itself, this law has two different elements. The state has to prove, rather, that you both possessed a drug and that you had an intention to sell that drug. So as far as the possession goes, they have to show that the drug itself was under your dominion or custody or control, and that means that the drug could have been held within your car or within your home, or even have been manufactured by you. But they do have to prove that there is a possession element in order to proceed further. The intent is a little bit more difficult for the state, because the people of the state have to prove through their prosecutors that you had a particular mental state, and if you haven't made a complete confession or admission that your whole intent was to sell drugs, they have to use the indicia or evidence that there was a sales transaction that was going to take place. That can be done sometimes through finding scales or baggies as part of a search, or by finding confidential informants that might have information that you had planned to set up a sale. Those are used to show the mental intent of the crime. And then of course they have to show that there was actually a sales transaction that was anticipated at some point. Even without specifics, they could show again by the use of baggies, scales, a pay-o sheet, messages on a cell phone, that there may have been a intent, or rather a transaction for sales, not just for personal use. This crime is particularly serious because it can hold you subject to prosecution with a potential sentence of 2, 3, or 4 years in state prison. If it's a first-time offense, then the judge would have the option, after hearing argument regarding mitigating circumstances from an attorney, to either consider the minimum amount of jail time, which would be, or state prison time, which would be 2 years state prison, or a probationary period where you wouldn't actually be given the minimum sentence, but would be placed on probation with other rules and regulations to be followed instead. In this type of law, search and seizure defenses are particularly fruitful, and you may find that a good attorney will be able to go through and take a look at Fourth Amendment constitutional issues, including whether or not the police had probable cause to investigate for sales, or whether or not they had information that would justify a search warrant. Those are particularly fruitful because if there wasn't a valid search, the entire case could be thrown out, which can be very helpful for these type of cases. That's why it's my recommendation that you consult with an attorney that is experienced in not only possession for sale cases, but in search and seizure law, because that will get you the best mileage as you come up with a strategy together, working with an attorney to defend these type of crimes. I wish you the best of luck, and I hope you watch the other videos in these series, and I will see you next time.